Okay, this is about the record excerpts that was actually filed on July 10th, but not submitted and put on record until July 29th. So here I'm just going to show you, that I'm being harassed for the whole month of August because clearly I turned my record excerpts in and I haven't heard nothing from them but just harassing calls about my record excerpts is not right and stuff like that. So, you can sit here and read it for yourself and telling me that the rules in the book are like, they got this rule, got that rule. I'll look the rules up. It's all about researching. You can look the rules up yourself. There is nothing stating about how they was explaining it. In other words, trying to throw a monkey wrench in something that they have done wrong. So they trying to clear up their mistakes. So we're gonna go on. And this all harassing emails back and forth. I got phone calls too showing the same thing. You constantly harassing me, but the day before you tell me on August 26th, you tell me after the email that I have to have my record excerpts in by a certain time. And if not, they're going to be stricken. So here I come with an email before anything was to transpire between two deputy clerks and also the pro se email of the Fifth Circuit Court of Appeals. And to read it out, here it goes. To Miss Magella Sutton and Dantrell Johnson of the United States Court of Appeals, Fifth Circuit, I am concerned on your issues with my record excerpts that have been filed in court documents. Please correct the misspelling of appellant's name when addressing directly to a person for proper correspondence. Clearly, there must be a misunderstanding of why the record excerpts are being hindered in these proceedings by the Fifth Circuit Clerk's Office. It seems that the two, Sutton and Johnson, have an interest in this case by aiding and suppressing my documents filed in this court. Motion to supplement filed earlier with no reason as to why it was denied. See below. The clerk's office and appellee's counsel have harassed me intentionally throughout the proceedings of case number 20-30286. There has been no explanation on anything submitted on my behalf showing it has been from the judge's decision. This portion is to Ms. Dantrell Johnson, who has engaged in a prior case when electronic records was shipped to the parties. See attachment. The Eastern District Court and the USCA Fifth Circuit Clerk's Office have not done this to case number 20-30286 in a manner in which it shows from another case. Appellant has requested the filings from district court and have not received any notification. The two mentioned, as stated above, an issue I would like to get clarification on is the 19-day delay of appellant's record excerpts. The record excerpts have a date stating July 10th, in which it was submitted, but was not filed until July 29th by the clerk's office. The court held the record for 19 days before filing the excerpts, a day before the appellee's brief. At the same time, nothing was wrong with the record excerpts prior, as stated, and nothing now. But to show you that the clerk's office and judges are supposed to be impartial, see Voigt versus Superior Court for clerk office involvement. I would like to communicate with your upper authorities over the both of your actions. There is still no word on the flash drive submission with a tracking number attached via certified mail. Not only has the clerk office intercepted my filings to prove a Title VII case, but interfering with the case has caused harm by jeopardizing my life and rights. As a clerk of court, you have a ministerial duty, and that is to be impartial and filing between the two parties in litigations. As mentioned earlier, in the Fifth Circuit Appellate Court, This office has denied the motion to supplement the record with no details, but it's denied at this time, as they say on the paperwork, with no other explanation, just it's denied at this time. That's the details. By the threatening messages I have received from your office, acting as a judge is questionable. Upon discussion, having the record excerpts stricken by a mandate and time frame chosen by the clerk's office, not by a judge, raises concerns for the outcome of the case. I have personally filed my documents by the rules and shunned by an office which seeks great interests in this case as well. This is a violation against my rights, once again, by the clerk's office, interest, and involvement with suppressing exhibits mentioned in the appellant's civil brief. Let the guilt be upon your hearts by having the record excerpts stricken under no significant statement. So to be brief, if any harm or bodily injury should happen to myself or family due to this ongoing case, illegal acts will be upon the courts and the appellees. There still is a pending protective order awaiting against the appellees and any third-party involvement. Performing wrongdoings, not upholding the law and sworn under oath, with the tampering and withholding information of any evidence presented by law to this court which will harm a case. The case will be viewed as intentional infliction upon any third party involvement and aiding a party. Under the Federal Rule 18 U.S.C. 2071, it states anyone who removes a document from the record can be punished. That's 18 U.S.C. 2071. And it states, A, whoever willfully and unlawfully conceals, removes, mutilates, obliterates, or destroys, or attempts to do so, or with the intent to do so, takes and carries away any record, proceeding, map, book, paper, document, or other thing filed or deposited with any clerk or officer of any court of the United States or in any public office or with any judicial or public officer of the United States shall be fined under this title or imprisoned not more than 3 years or both. B, whoever having the custody of any such record, proceeding, map, book, document, paper, or other thing willfully and unlawfully conceals, removes, mutilates, obliterates, falsifies, or destroys the same shall be fined under this title or imprisoned not more than 3 years or both, and shall forfeit his office and be disqualified from holding any office under the United States. As used, the term office does not include the office held by any person as a retired officer of the armed forces of the United States. Respectfully submitted, Brandon L. Brackens, pro se litigant and appellant, case number 20-30286.